Hey everyone, Clint Coons here, and in this video, I wanted to put together something that addresses a common question I get, and that is, how do you buy property subject to and make sure you're protected? All right, let's get started. So when you're buying property subject to, the risk that most people think of is what happens if the lender finds out about it? Because remember, in a subject to transaction, what you're typically doing is you're buying property subject to an existing mortgage. So here's a seller right here with this piece of property. This is the seller. And the seller wants to sell me this house. It's typically they're in a distressed situation. They're behind on taxes. They're behind on the mortgage. So what the buyer is going to do over here is the buyer is going to come in and make an offer to acquire this asset. And typically it's going to be, hey, I'm going to reinstate the mortgage, bring it current, pay all the back property taxes, get all the liens, everything else picked up. So I'll take care of that for you. And maybe I'm going to give you a couple grand as well on top of that. And then you're going to deed me the house. That is the sale right there. You're going to transfer the real estate to me. Now, when they transfer that property to you via deed, they remain subject to the original mortgage. That is, we're not paying off the original mortgage. This property could have a mortgage on it for $170K. That's going to stay there because this individual, this buyer who's buying the short sale, they don't want to use their own credit, right? Why not pick up a property that has an existing mortgage on it, doesn't require you to go out there and get a loan? Because the loan was already obtained by this individual. All you're agreeing to do is, hey, I'm just going to keep it current. I'm going to keep paying it. And then you turn around and you're going to rent this out to a family who's going to move in there and then pay you rent every month. And you're going to turn around and pay the mortgage and then keep the difference. That's how this typically works when you're buying property subject to. Now, this individual over here many times that has purchased a property from you, you have to let them know the entire transaction. In fact, I've told people, have them have your contract reviewed by a local attorney so it protects you from them later coming back against you and saying, well, I didn't understand. I didn't know this mortgage was still going to show up on my credit and I was still going to be responsible for it. So it's always good to make sure that they've had the opportunity to seek independent counsel to review the transaction, explain to them what their rights are in this agreement and potentially what challenges they may face if you don't pay the mortgage and so forth. So that's always important. But what's equally important though is how do you transfer this title from somebody here to you via this deed without getting the bank alerted to the fact there's been a transfer? Because there's always that concern that if the bank finds out, well, they may accelerate because they might be on heightened alert because this person was already behind on their mortgage. So here's some of the creative techniques that people have come up with. One, set up an LLC, put it in a limited liability company, and then transfer the LLC to this individual buyer over here. That works great. But if the bank looks on title and they see it's held in a limited liability company, they may assume now that the homeowner sold the property to an investor. And the homeowner, of course, is still liable on the note. They're not going to want that. So that's a problem. Now, the likelihood of that occurring, it's probably not huge. But if it concerns you, then your other option is to use a different tool. And that tool is referred to as a land trust. And if you've been a student of my channel for a while, I've got plenty of videos on land trusts. I'm not going to go into how a land trust works, but the reason why a lot of subject to investors use land trusts, it's to not alert the bank should they look to the fact there's been an actual transfer of that real estate to the end buyer investor. So with the land trust, they're going to set up the land trust here. And the seller will deed the property into the land trust. So they deed the property into the land trust. And you're going to be the beneficiary down here on this land trust. You're the Benny, you. So they transferred into the land trust. Now, when you take title in the land trust, you're always going to take title in the name of the trustee, name of the trust. So, Susie Q, trustee of the Greenhorn Land Trust is how title might be taken. So I've seen a lot of investors say, well, they will use the seller as the initial trustee on their trust. So we'll set it up that way. This is Susie, Q, they'll have her be listed as a trustee, deed the property into the trust, and then after the property's been transferred into the trust name, Susie resigns and Karen steps in here as a successor trustee, is Karen. And no one knows about this. So if the bank looked, they would think that Susie created an estate plan, and they're not going to accelerate on the estate plan because they're going to allow it to go into a trust. They don't know what's the mechanics of the trust because it's not recorded anywhere. All right, so what's the risk in doing this? The risk in keeping Susie Q on there as trustee initially is that if anyone looks, they assume, like the bank does, that Susie still owns the property. So what could Susie do if she felt so inclined? You've probably already figured it out. Why couldn't she just sell it to another person? Because another party would look, title would look, they would see her name on there as trustee of this trust. She provides them a trust agreement that she just makes up. She finds something on the internet, types it all up, lists herself as beneficiary, gets it notarized, gives it to the title company. Now she can close in the name of this trust. She has a bank account set up. She receives the proceeds. Next thing you know, you've lost the property. That is the risk when you leave the seller on there as the trustee. So what is an option then for you when you're buying subject to avoid this? Well, there's a couple things you could look at. Number one, use an LLC as the trustee. So you have your LLC set up. Typically, I use a Wyoming LLC as the trustee, so their name is not going to be listed there. Now, could this make a bank think, well, maybe this is a transaction, they did sell it to an investor? Yeah, you could do that. Or another way to do it is how you take title. Okay, so if you look at the way you're taking title, maybe you do not list the trustee, you only list the trust name down and you leave the trustee off, and you just have the trustee sign at the bottom. The risk in doing that is that you make cloud title and make it difficult to sell the property in the future. But I've had individuals that I've worked with that are real estate investors that tell me they avoid putting the trustee's name down when they're buying subject to because they're concerned about that, the bank looking and seeing that third party there. At the end of the day, it comes down to this. If you want the most protection when you're putting together a subject to deal, all right, don't use the seller as the initial trustee of that trust and leave their name on there because that information is going to be publicly available to a lender. If you did want to do that because you're concerned that the lender might look, give it a seasoning period then. When you go through this transaction, have the seller, of course, give you a trustee's deed. This is critical. Okay, it gives you a trustee's deed, which transfers the trusteeship to you for recording purposes, and then leave that seller on there for, say, 6 months, and then go down and then put yourself on. Or better yet, what I would suggest you do is use that Wyoming LLC as the successor trustee. So rather than Karen, she has a Wyoming LLC set up here. That's what the trustee will do. It states that when Susie's is no longer serving, then the Wyoming LLC takes over. So get that trustee's deed from her and record that in 6 months. So you would shorten that time frame where you're going to be at risk. It's just a part of investing, right? There's always going to be some risk when it comes to investing in real estate, subject to deals. Your greatest risk is going to always be the lender if they accelerate. In my experience, it doesn't happen very often because banks are in the business of loaning money, not owning property. And as long as that mortgage is being paid and it's current, they really don't have an incentive to look. But use this as your guide going forwards. If we can be of assistance to you, be sure to set up a strategy session with our firm. It's in the show notes. Other than that, all the best with your investing.